A very good morning, a very good evening to everyone here. I'm in a different time zone, so I'm very confused about that. Welcome to our panel event, The State, Sex and Sexuality in South Asia. I am Sahana Karthik, the co-convener of the UCL South Asia Forum, a platform wherein we analyze issues pertaining to this region through a legal lens. I will be moderating the event this evening as our incredible lineup of speakers, Dr. Rukmini Sen, Dr. Rama Srinivasan, and Dr. Swati Shah, discuss how legislation and legal tools can be instrumentalized to secure sexual autonomy and fundamental human rights. The lack of autonomy accorded to women and members of the LGBTQ community in the most extreme of cases can directly result in death. According to a study by the World Bank, 40% to 70% of women's deaths from violence are caused by intimate partners, often within the context of abusive relationships. Reports also indicate that self-immolation, suicidal thoughts, and honor killings are prevalent in South Asia because of the violence and abuse by intimate partners and following disclosure of sexual harassment. Governments can be instrumental in how violence against women is addressed. According to some research from the region, however, many government services provided reflect a patriarchal gender bias. Police officials often lack gender sensitivity, and in Sri Lanka, officials commonly record incidents of intimate partner violence improperly as accidents, rather than categorizing them as punishable offenses. All 8 countries in the region, Nepal, India, Afghanistan, Maldives, Sri Lanka, Pakistan, Bhutan, and Bangladesh possess laws that have codified pre-existing frameworks of religious legalism or morality to a greater or lesser degree. Legal reforms that must be compatible with pre-existing religious frameworks have the potential to serve as barriers to enhancing the rights of women, girls, and the LGBTQ community. For example, the Shiite laws in Afghanistan enables husbands to end financial support to wives who do not fulfill sexual duties. Marital rape is not criminalized in Afghanistan, Bangladesh, India, Maldives, Pakistan, or Sri Lanka. Inheritance laws in Maldives and Pakistan still prevent women from acquiring shares equal to those of male heirs. There are also laws regarding zina, or extramarital sexual relations, which allow for a convicted woman to receive lashings as a punishment. This exists in Afghanistan, Maldives, and Pakistan. Further, colonial-era laws prohibiting same-sex relations are commonly found in the penal codes of this region. Regulations that safeguard the existence of LGBTQ individuals in Pakistan, Maldives, and Afghanistan have to grapple with the presence of Sharia law. There has fortunately been some progress in recent years with regions developing laws against violence faced by women and girls and according self-determination to minority communities. All 8 countries have specific constitutional provisions addressing gender equality. Similarly, all have signed the Convention on the Elimination of All Forms of Discrimination against Women. India's Supreme Court decriminalized homosexuality in September 2018. Nepal had a landmark ruling in 2007, which resulted in legal protection for LGBT individuals, as well as official recognition of a third gender. In subsequent years, similar legislation acknowledging a third gender was enacted in Pakistan, Bangladesh, and India. Pakistan celebrated its first Trans Pride Parade 2 years ago. Moreover, Sri Lanka and Bhutan have allowed people to change their legal gender. Now, in the context of this, we first have Dr. Rukmini Sen. She is a professor of sociology in the School of Liberal Arts at Ambedkar University, Delhi. She has also served as an executive committee member for the Indian Association for Women's Studies, is a member of the core group on women at National Human Rights Commission, New Delhi since 2019, and a member of the editorial board for the book series International Perspectives on Gender-Based Violence. Dr. Sen, over to you.
2018 was an important year in the judicial history of India, especially in connection to intimacy and sexual relationships. 3 Supreme Court judgments of 2018 will form the primary basis of today's presentation. Within the broad theme of the panel discussion, as Sahana has already set the tone, the state, sex, and sexuality in South Asia. I thank the organizers, South Asia Legal Forum of the University College London for holding this really important conversation, and eagerly looking forward to listen to also my co-panelists. I have titled my brief presentation as The Choice to Love, Judicial Liberty and Social Dependence. And I moved through, as I said, 3 moments of 2018 in terms of Supreme Court judgments, talk about some of the extracts from these judgments to discuss certain binaries in which the judgments itself are actually getting articulated, and then eventually end with certain questions. So the first of these judgments came on March 8, 2018, Shafin Jahan versus Ashokan KM and others. This is popularly known as the Hadia case in the Indian context. It involves, and since I don't have the time to get into the details of the case, very briefly, it definitely involves a choice of partner with respect to marriage. There is a conversion, and then there is marriage. So it's also an interfaith marriage that is happening. It goes to court primarily because the father of the daughter has, problem with this marriage that takes place, warrants custody of the daughter, a daughter who is, of course, an adult daughter, and eventually it goes to court. She is an adult woman. She decides to marry a person of a different religion, converts into that religion, and she's also someone who is a professional who is studying homeopathy medicine in a college in Kerala. So this is the broad background. In this context, when it reaches the Supreme Court as an appeal, the Supreme Court emphasizes in this judgment the right of self-determination. And I quote from the Supreme Court judgment, which says, the fundamental tension between autonomy and security is difficult to resolve. It is also a tricky jurisprudential issue. Right to self-determination is an important offshoot of gender justice discourse. At the same time, security and protection to carry out such choice or option specifically, and the state of violence-free being is another tenet of the same movement. And I think it is this tension between self-determination on the one hand and protection and security on the other hand, which kind of comes within this one paragraph of emphasizing right to self-determination of this girl, is an important binary, is an important contradiction that we need to remember when we do talk about question of autonomy, which the Supreme Court is highlighting, but is also as if trying to talk about it in connection with protection and security for women. That's the first. The second thing that comes from this particular judgment itself is the expression of choice in accord with law is acceptance of individual identity, curtailment of that expression, and the ultimate action emanating therefrom on the conceptual structuralism of obeisance to the societal will destroy the individualistic entity of a person. So what the court actually talks about is now a binary, if I may, between social values versus constitutional freedom. So the constitutional freedom to choose versus the social values, which the court says has its own space. This particular judgment quotes another judgment. Again, this is a judgment which has constantly been quoted in, self-choice related judgments that we've seen in the recent times. It's Lata Singh versus State of Uttar Pradesh, a 2006 Supreme Court judgment. And in this particular judgment, there is, a couple of sentences that I want to quote from this judgment, which says, this is a free and democratic country, and once a person becomes a major, he or she can marry whosoever he or she likes. If the parents of the boy or girl do not approve of such intercaste or interreligious marriage, the maximum they can do is that they can cut off social relations with the son or the daughter. So what the court judgment, Lata Singh is saying, and this is something which we see even in the Hadia judgment, is making again some kind of a binary or probably a coexistence between the choice that is made by the son or the daughter in terms of who the person would marry vis-a-vis a parental disapproval. So marriage between any two persons in India can actually be solemnized under the Special Marriage Act of 1954. And it is the Special Marriage Act of 1954 which allows interfaith and intercaste marriages. However, in order to get married under the Special Marriage Act, a notice of this intended marriage needs to be filed with a marriage officer 30 days prior to the date of marriage. And any person can raise objection to the marriage, and by saying that it contravenes the conditions of solemnization of this marriage. Interestingly, a petition has been filed in the Supreme Court on August 31st, 2020 about the need to file these personal details if you have to marry under the Special Marriage Act as a violation of Article 14 of the Indian Constitution, which is equality before law and equal protection by the law. The petition states, and I quote, "Publication of personal details often might have a chilling effect on the right to marry." In other words, couples are asked to waive the right to privacy to exercise the right to marry. And that becomes, you know, the most contentious thing around the Special Marriage Act. The Tamil Nadu government in 2018 had a very different thing to suggest, not in terms of the Special Marriage Act, but actually in terms of the Hindu Marriage Act. They suggested, the Tamil Nadu government came up with an order that two consenting Hindu adults marrying under the Hindu Marriage Act, but without the knowledge of their parents, will not be able to register their marriage unless they have access to the original documents relating to their parents' identity and address. And if any one of them is no more, they need to provide their death certificates. So I think what I'm trying to actually say is that, you know, think about the Special Marriage Act. While of course it is something which is very important for us to claim and hold on to, yet this 30-day notice period is something which is definitely problematic. And also think about the Tamil Nadu government order and see that, you know, adult consensual marriage itself is being put to question. I come to the next moment, which is September 6, 2018, when the Supreme Court delivered what is known as the Navtej Singh Johar and others versus Union of India, which is what, Shahana, as you mentioned, the Section 377 judgment decriminalizing homosexual behavior. While I quote from this judgment, one section of the judgment quotes a poem by Vikram Seth. And there are only a couple of lines from that poem that I would want to quote before I get to, you know, some of the details of the judgment. The poem is titled, "Through Love's Great Power." Through love's great power to be made whole in mind and body, heart and soul, through freedom to find joy or be by dint of joy itself set free in love and in companionhood. This particular judgment, the Navtej Singh Johar judgment, relies quite heavily on the right to privacy, something that was already guaranteed, you know, by a previous judgment before the Navtej Singh Johar judgment, which is, you know, again, commonly known as the Puttaswamy judgment. What the Navtej Singh Johar judgment quotes from the right to privacy that comes in Puttaswamy, which is relevant for our discussion today, is privacy is a postulate of human dignity. Thoughts and behavioral patterns which are intimate to an individual are entitled to a zone of privacy where one is free of social expectations. In that zone of privacy, an individual is not judged by others. Privacy enables each individual to take crucial decisions which find expression in the human personality. So there's a very important position that I would think not just Johar, but also Naz takes around the question of right to privacy when it talks about, the right to love across, sexual orientation. But all of this, I would think, in the Johar judgment is couched in a concept and a principle which has, again in 2018, but even probably before that, become very important within Supreme Court judgments, and that is called constitutional morality. And the Johar judgment says, constitutional morality reflects that the ideal of justice is an overriding factor in the struggle for existence over any other notion of social acceptance. It builds and protects the foundation of a democracy, without which any nation will crack under its fissures. Constitutional morality must turn into a habit of citizens. By respecting the dignity of LGBT individuals, this court is only fulfilling the foundational promises of our Constitution. The question, however, still remains that whether constitutional morality is really a habit of citizens. And, while the court, pronounces it and wants it, that it needs to be a habit of citizens, how is that habit to be constructed and how is that habit to be inculcated is something that is left for, us to actually think about. The last thing that I want to say with respect to the Johar judgment is the choice of a partner, the desire for personal intimacy, and the yearning to find love and fulfillment in human relationships have a universal appeal, straddling age and time. In protecting consensual intimacies, the Constitution adopts a simple principle. The state has no business to intrude into these personal matters, nor can societal notions of heteronormativity regulate constitutional liberties based on sexual orientation. While this is extremely important to talk about the autonomy of choosing partner versus, the state cannot intervene in personal matters, my concern with this kind of an argument is that the state actually intervenes in personal matters. And there are matters which we actually take to the state, be it matters relating to domestic violence, be it matters relating to reproductive choices, abortion, etc. So to frame, the entire debate around the question of the choice to find a sexual partner or the choice to love, when it is framed around privacy and liberty, and not wanting the state to intervene into personal matters, then it could be a limiting argument in itself. The final moment would be September 23, 2018, Joseph Shine versus Union of India, commonly known as the adultery judgment. So, again, the provision of adultery that we have in the Indian Penal Code, which comes under, issues relating to marriage within the Indian Penal Code, Section 497, it was about treating women like chattels as property of men very clearly. Women occupied a liminal space in the law. They could not prosecute for committing adultery, nor could they be aggrieved by it, by virtue of their status as their husband's property. So Section 497 is clearly premised upon sexual stereotypes that view women as being passive and devoid of sexual agency. And, adultery provisions actually run across different criminal law provisions in South Asia. It is not something which is only specific to India. So in this particular kind of a view, women are bereft of the ability to decide, to make choices, and give free expression to her personality. Human sexuality, and the court says, is an essential aspect of identity. Choices in matter of sexuality are reflective of the human desire for expression. Sexuality cannot be construed purely as a physiological attribute. In its associational attributes, it links up with the human desire to be intimate with a person of one's choice. The court continues and then eventually says, the court pronounces, it is the duty of the court to break stereotypes like this associated with women and promote a society which regards women as equal citizens in all spheres of life, irrespective of whether these spheres are public or private. So even in the adultery judgment, what we actually see, and I'm kind of trying to think that is something that we saw even in the Hadi judgment around self-choice vis-a-vis partner, is, this complex binary between what does the court or what does the law understand women to be in the zone of protection or in the zone of property. So clearly we've moved from property to protection, but together with it, side by side, how do you ensure, choice and liberty? So that's the zone again that the adultery judgment, kind of comes us with. Very recently, and I'll not get into the details of this, very recently in November 23, 2020, we have the Allahabad High Court, which pronounces, again, a very important judgment around interfaith couples and actually says, takes names of these two persons, a man and a woman, one Hindu, one Muslim, and says that we do not consider them as Hindus and Muslims, but we actually consider them as consenting adults who would want to marry. And in that context, parents or, the broader society cannot say anything about it. While all of this, and as I said, 2018 seems to be, I'm sure we will look back to 2018 in some significant way in the Indian juridical framework, which kind of gives us a certain kind of intimacy related jurisprudence, I think, all of which seems to be couched under choice and liberty. I feel that, those seem to be the pivotal, legal conceptual arguments through which these judgments come. While that is important, in the history of feminist legal politics in India, it is necessary, however, to be mindful of that what goes to court is actually the tip of the iceberg of ways of social constraints and dependence, interdependence, through which everyday lives of women and people with other marginality lead, where negotiations, resistance, and playing with, as well as reclaiming gender, caste, religious, sexual identities constantly happen. A country which definitely has more arranged marriages than self-choice marriage or cohabitation. While freedom to choose is juridically guaranteed, lived realities of love and intimacy could be propelled by secrecy, elopement, cutting off ties with kinship, living by sacrificing love, with social and legal non-recognition, or even death by suicide. And I'm kind of trying to say that that's the ambit through which everyday lives can be led. To exercise that liberty that the court is guaranteeing us. I'll stop. Thank you very much.
Thank you very much, Dr. Sen, for those comments. They were very insightful. We'll move on to our next speaker for the evening, Dr. Rama Srinivasan. Dr. Srinivasan is a Mary Skłodowska-Curie Fellow at Safoscari University of Venice in the Department of Asian and North African Studies, having obtained her PhD in anthropology from Brown University in 2017. She also authorized a monograph published in early 2019 titled Courting Desire, Litigating for Love in North India. Please, Dr. Rama Srinivasan.
Okay, thank you so much, Sana, for the introduction and this invite. I have to say this actually early 2020, but yeah.
I apologize.
But thank you. And yeah, Rukmani, it's great to have heard your talk because now I can kind of really structure. I see that our talks are very complementary. So this is going to be very helpful that you have set the ground here. So in this talk, I will address the question of choice, consent, and self-determination, afforded to individuals on the question of marriage, civil partnership, and intimate relationships in general, but as well as legal options available to women and marginalized groups in South Asia. When I was planning my research on legal interventions in cases of elopement in North India, I let lawyers guide me on the kind of cases I should track. These were by and large protection petitions with a small percentage of habeas corpus and abduction cases. In the social milieu, protection petitions, preferably at a higher court, has become the standard advice most couples who want to get married receive from people in their own social circles, as well as lawyers practicing at the district courts. A protection petition is a criminal case filed by couples who testify that their lives are in danger as a result of their decision to defy family and get married. In the period between 2012 and 2018, I'm sorry if I'm speaking really fast, but yeah, when I had tracked cases at the Punjab and Haryana High Court, there was no realistic assessment on the level of threat other than the instances where families of women appeared on court premises and even in court rooms to argue against the match. Seasoned lawyers and court-appointed legal officers told me that the physical threat could actually be minimal or non-existent, since many of had not even discussed marriage with their family members before elopement. But in my own interviews with such petitioners, couples either reported attempts by reported attempts by family members to separate them or find suitors for the women, or they feared that if families would try such may take such actions if a conversation was even broached. In most cases, it was a woman's family that made this objection, but I met at least 3 couples where the man's family was listed as the ones threatening the couple. So for the couples I interviewed, a court marriage in courts was a non-messy way to get their marriage approved in the absence of a social sanction, and the expectation was that families would at the very least not interfere or harass them if a court order was secured. Protection petitions were, of course, not an equivalent to a court marriage, which is usually conducted at a magistrate's office. Apart from the Special Marriage Act, which offers the most reasonable option for civil partnership, personal laws also offer couples an opportunity to register a wedding conducted through religious ceremonies. In North India, both interfaith as well as intra-faith couples mostly applied to courts for protection, and the court order, although not a guarantee, gives them the kind of legitimacy to start their married life together. This could be because, as Dr. Sen had already highlighted, the issues with the Special Marriage Act, including the permanent address requirements, but also the privacy one. I should mention here, though, that both the Allahabad High Court and the Punjab and Haryana High Court had actually struck down the display of names on the grounds that it was a violation of the privacy judgment in the Supreme Court. But bureaucracies, by and large, do not seem to have woken up to this. Anyway, so getting back to my talk, see, at the very least, police cases of abduction are not pursued in cases once a court order has been procured. The success of these procedure is owed largely, like Professor Sen had mentioned, that the 2006 Supreme Court judgment, Lata Singh versus the state of Uttar Pradesh, which had mandated that the state government to safeguard couples against crimes such as honor killings, and that the police officers do not harass couples. The precedent set by this verdict has today created an entire legal apparatus devoted to facilitating marriages that ideally should have been served by the Special Marriage Act or personal laws. But why is the procedure relatively more successful, and what are its limits? So, protection petitions are filed as writ petitions with reference to Article 21 of the Indian Constitution, which deals with the fundamental right to life and liberty, which can in principle not be denied, but we increasingly see that Indian courts are not taking this into consideration in many cases. But in principle, fundamental right to life and liberty cannot be denied. So while Article 21 was widely used in court proceedings, it did not appear that the right to marry was a fundamental right. It only went so far as to ensuring that the couples may live their lives as they desire without interference or harm. And yet, many judges peruse the paperwork carefully to establish the veracity of the claim of marriage. These efforts produce different dialogues in various courtrooms, but court orders of several judges contain a variation of the phrase, while not going into the validity of the marriage. The use of the term court marriage in this context is evocative of the research in legal studies, which on the idea of legal fiction, that is a statement assumed to be accurate for legal purposes, but may actually only be partially true or even completely false. The judges accepted the couple's perception of threat, while couples read the judge's approval of the wedding, although neither was an established legal fact as far as the court proceedings are concerned. So the court procedures I observed tentatively upheld the right of an adult citizen to marry a person of their choice, at the very least to be with their lover. Even if the couple's futures are entwined, a woman's statement in court that she had eloped to marry of her own choice or marzi is an exercise of consent, and its recognition at court is a validation of their adulthood and rights as a citizen. Whereas women get to articulate their choice in many courtrooms, men were usually not called upon to do so. Less than a month after the Supreme Court decriminalized homosexuality in September 2018, a lesbian couple from Rajasthan had petitioned the Delhi High Court for the protection of their life and liberty, which they insisted was under threat from their families. The petition included a statement that the women wished to marry each other, although there is no such law to support such a marriage at the moment. And there is a petition, like I think it was in there. I think a court has taken up in January 2021, 3 petitions to legalize gay marriage and Hindu Marriage Act, Special Marriage Act, and Foreign Marriage Act. So it could be of interest. The petition that these women they included a statement that families of one of the women had forcibly engaged her to a man, and their wedding date was set for like a month later. And the Delhi High Court did grant a protection petition to these women. Other than that, the protection petitions have been in focus in the last few months with an explosion of the so-called anti-love jihad campaigns in UP and elsewhere. And This has, of course, left me wondering whether this legal procedure would continue to aid couples or not. Or maybe that, like the labor apparatus, can outlive such political campaigns is something for us to watch out for. So the proposed laws and ordinances that mandate that those who wish to convert to another religion notify the district authorities at least 1 month in advance, create problems similar to the ones faced by Special Marriage Act already with its 1 month's notice period. So it in effect kind of limits all options for interfaith couples. So, but also the other thing that has come up is that investigative reports, news reports have suggested that local Hindutva outfits have created an extensive machinery across North India to curb such marriages with spies in district courts, including clerks and lawyers, who inform groups about such any petitions that are filed or even visits for initial inquiries. An article in the print interviews a Vishwa Hindu Parishad functionary who claimed that they just get the girl back and marry her to one of their home. So I'll quote, I mean, it is horrifying, but I'll quote a little bit of this person's interview. He says the wedding happens, the wedding to one of their own happens without the woman's consent. We force it. The woman's consent is anyway not important. Her family should be on board. That's it. So this discourse in many ways tries to, I think, delegitimize, but also reverse the gains that I have mentioned with the protection petitions and the legal systems that have tentatively upheld the idea of adulthood and rights as a citizen, which I talked about, but we really don't know what is the future at the moment. But to just talk a little bit, I don't know how much time I have, but to talk a little bit about these interfaith marriages in light of what I discussed earlier, as part of a 2014 judgment on 5 cases involving Hindu women who converted to, okay, 5 minutes, Hindu women who converted to Islam, they were clubbed together as Noor Jahan Begum and others versus the state of Uttar Pradesh. And the Allahabad High Court posed the following question: is conversion of religion of a Hindu girl at the instance of a Muslim boy without any knowledge of Islam or of faith and beliefs in Islam merely for the purpose of marriage valid? Although Justice Kesarwani admitted that this is difficult, if not impossible, to define and delimit the expression of religion, he held that it was a matter of personal faith, one that must stem from the depths of the heart and the mind. And Justice Kesarwani was ostensibly privy to the depths of the hearts and minds of all 5 men whose faiths he ruled on that day. According to his order, conversion, if separated from efforts to transmit and spread the tenets of religion, was an infringement of freedom of conscience guaranteed to all citizens. In his judgment, in effect, he held that an adult woman who exercises her freedom to convert and to another religion was in some way stripped of her own constitutionally guaranteed freedoms as a result. In Salamat Ansari versus State of Uttar Pradesh, which Dr. Sen had mentioned, so I'll just say this quickly, that the same High Court held that its own 2014 judgment was not laying good law. So yeah, and to just wrap up, maybe I would talk about a little about, since it's a South Asia forum, I'll talk about the fact that though an option of civil union exists in principle in India, a 2019 case from Pakistan attracted my attention because the commentaries from lawyers and activists who mourn the lack of such a law in Pakistan. This case referred to a 19-year-old Sikh woman, Jagjit Kaur, now Ayesha, who had eloped and converted to marry a Muslim man of her own choice. Her parents alleged that it was a case of abduction and forced marriage, and the Punjab state in Pakistan, and even the central government got involved in the matter because it was actually just a few days before the Kartarpur border was opened. So they didn't want an international controversy. So coming back to this, the couple was separated, but Ayesha refused to convert and convert back and return to her family. After spending a year in a woman's shelter home, she was finally allowed by the Lahore High Court to return with her family, with her husband. The story is quite familiar to in the Indian context as well. The case of Hadia, which Dr. Sen mentioned, is probably the best known example of a woman who well in her 20s was forced to return under the guardianship of her parents. So I'll probably just finish by saying that the infantilization that Hadia witnessed in her struggles is something that we are all witnessed with the rhetoric around Khap Panchayats and then the Hindutva outfits, where women are represented as gullible and incapable of making their own choices. Courtrooms are not immune to this rhetoric, but they still seem to offer some hope for exercise of choice and consent. I'll stop there.
A massive thank you to all our speakers this evening, in the first instance for accepting our invitation and for also their time today on behalf of UCL SALF. And I would also like to thank you, our audience, for attending and for all the questions posed. The UCL SALF would also like to extend our gratitude to Ms. Kat Baligan from the UCL Laws events team for her continued support. If you'd like to reach out to us following the event or would like to ask us any further questions, you may find us on Instagram, Twitter, or Facebook at UCL SALF, or you can email us as well. Our link is in the bio to all of these pages. Thank you and have a great evening, everyone.